Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. The summer marathon of immigration decisions is in full swing. 9 cases this week. Heads up as well, y'all. A district court in Nevada recently used the Patel decision to dismiss a mandamus action challenging USCIS undue delay in adjudicating an I-601A waiver. That is a big deal if adopted elsewhere. Let's not let that happen. Thanks for the heads up, Josh Altman. On the other hand, the Ninth Circuit denied Oil's petition for en banc rehearing in the uber-important Muñez v. Department of State decision that concerned the doctrine of consular non-reviewability, discussed on episode 128. Might be heading to the Supreme Court. It's that important. Let's see what happens. Again, huge week of cases, kicking it off with 4, count 'em 4, from the 4th. Kicking it off with Chicas-Machado v. Garland, published by the 4th Circuit on July 13th, 2023. This case is about asylum. Ms. Chicas-Machado is an asylum seeker from El Salvador. She, quote, started attending evangelical church, the Pentecostal church, in 2014. She became a member in 2015 and eventually acted as the church's secretary, end quote. Gonna stop just right there. From the onset, we know that Ms. Chicas-Machado wins, and that she's telling the truth in this decision. But strategy-wise, if possible, it's very smart to tie a gang-based asylum claim to religion, as religion is itself a protected ground, thereby avoiding having to do the whole particular social group or political opinion thing. I don't know if that's what happened here. I'm only on page 2. We'll see. Also, of course, assuming the facts of your case support such an argument. Anyway, in late 2015, MS-13 members began harassing Ms. Chicas-Machado as she left church. And those MS-13 members told her that she was, quote, their enemy because I used to spread the word of God and because I wanted to tell the young people to attend church, end quote. Pretty good nexus quote. Things escalated a year later when MS-13 members threatened to kill her. They wanted to use her to commit crimes, as no one would suspect a good Christian girl. Instead, she reported it. The police promised that they'd detain the gang members. Instead, the MS-13 members came to her home 2 days later and threatened to rape and kill her. They had disfigured and murdered her uncle in the past. She knew they were serious. And MS-13 had similarly threatened other church members. She fled for the United States in December 2016, arriving on Christmas Eve. What were you doing Christmas Eve 2016? And yes, indeed, Ms. Chicas-Machado eventually argued that she had been targeted because she wasn't an evangelical Christian, and that MS-13 systemically targets evangelical Christians in El Salvador. Are we about to get a pattern or practice ruling out of the 4th for evangelical Christians? This Jewish boy can hope. Neither the immigration judge nor the BIA believed that religion had much of anything to do with Ms. Chicas-Machado's experience or fears. The Fourth Circuit disagreed. Religion need only be one central reason for the persecution suffered and feared. It need not be the sole one. That's how asylum works. And after all, remember, Ms. Chicas-Machado testified, in testimony deemed credible, that MS-13 literally told her that they were targeting her because of her, quote, activity and conduct with the church, end quote. The BIA made a classic mistake, said the Fourth Circuit, that quite frankly is quite muddy and probably not a mistake everywhere, and would certainly be the rule that Bill Barr and Jeff Sessions would prefer. Maybe Jeffrey Rosen? But in the Fourth Circuit at least, the nexus standard doesn't require that the persecutor have an animus towards the protected group or the protected ground, or that the persecutor be trying to overcome that characteristic in the persecuted. Nor in the religion context, which is one of the 5 protected grounds, need the persecution be, quote, motivated to stop or hinder her from practicing her religion, end quote. Instead, even if, as the BIA believed, Ms. Chicas-Machado's, quote, use as a potential asset to the gang because no one would suspect her given her activity and conduct with the church, was inextricably intertwined with her religion, end quote, that satisfies nexus to religion, or to particular social groups, or families, or political opinions as applicable in the Fourth Circuit. Oh, and by the way, the 11th Circuit and the 10th Circuits have agreed in unpublished decisions cited within this published one. Restated, quote, the gang's threats of death were directed at Ms. Chicas-Machado, and not another person, because she was a practicing Christian and an active member of an evangelical church, which made her useful to the gang, end quote. That was sufficient to establish a nexus between the harm suffered and a protected ground, here, religion. The analysis doesn't, quote, depend on the ultimate goal of the persecutor, end quote. It's really just why, or one central reason why, the person was targeted. In light of this and the other stuff you're about to hear and heard last week out of the Fourth Circuit, anybody selling a home in Virginia? I need to get to the Fourth. Heck, I'll even take West Virginia at this rate. Now, the BIA also appeared to believe that actually MS-13 just amped up the attacks because Ms. Chicas-Machado went to police, not on account of her religion. A bit cynical if you ask me, because asylum law often does now require these asylum seekers to have gone to police to establish the unable or unwilling to protect prong, but let's put that aside. Unsurprisingly, the Fourth Circuit didn't think that mattered for nexus. Even if that is what happened, that MS-13 amped up the attacks when Ms. Chicas-Machado went to the police or because she refused to help them, quote, retaliation for reporting or threatening to report activity to the police does not negate what would otherwise be nexus to a protected ground, end quote. In any event, the Fourth Circuit majority saw this as a clear case where indeed MS-13 was preventing Ms. Chicas-Machado from fully practicing her religion. At a minimum, the death threats and other stuff had a, quote, chilling effect, end quote. Remember that. Also, the BIA misunderstood the record, some other findings. It's all getting remanded, and of course now the government has the burden to rebut Ms. Chicas-Machado's well-founded fear. No small thing given the recent gang decisions coming out of the Fourth. The denial of Convention Against Torture Protection was affirmed, though. In this decision, the Fourth Circuit analyzes a lot of good other asylum decisions out of the Fourth, especially in the particular social group family context. No pattern or practice holding that MS-13 persecutes evangelical Christians in El Salvador, though. Oh well. I mean, great for evangelical Christians in El Salvador, but it'd be a lot cooler if you held it, Fourth Circuit. Congratulations, Daniel Warren Tillman, for petitioner. More. Lots of the majority opinion was actually directed at Judge Agee, who issued a long and passionate dissent on the asylum stuff. Quote, the nexus reasoning adopted by the majority here, and as reflected in some of this court's earlier decisions, is an aberrant construction of immigration law as historically understood, untethered to the statutory text as written by Congress, and rejected by several of our sister circuits, end quote. Word? Finally, there's this from one of the majority's footnotes. Quote, That the Salvadoran government is unable or unwilling to control MS-13 gang members is not disputed in this appeal. End quote. That's Oil speaking for the United States government as regards MS-13 in El Salvador, arguably from 2014 to 2016. And that is Chicas-Machado v. Garland. Our next of four, Trejo Tepas v. Garland, published by the Fourth Circuit on July 10th, 2023. This case is about the rights and immigration proceedings of pro se asylum seekers, an issue last discussed by the Fourth Circuit in Quintero v. Garland, episode 57. So really, this case is about Quintero v. Garland. Mr. Trejo Tepas is from El Salvador and sought admission into the United States at a port of entry in April 2016 at the age of 16. He was by himself, no parent, guardian, or anything. He was placed in removal proceedings and taken into the custody of the Department of Health and Human Services, Office of Refugee Resettlement, as occurs with unaccompanied minor children. After 2 weeks, though, he was released into the care of his father, who was then apparently living in Maryland. Mr. Trejo Tepas appeared for 3 removal hearings accompanied by his father. At the 4th, still without an attorney though, he conceded removability and indicated that he was afraid to return to El Salvador. The immigration judge advised that Mr. Trejo Tepas file an asylum application and provided him with the instructions, information, and consequences of not doing so within 1 year, as well as how he might be able to get excused from doing so within 1 year. As by this point, this 4th hearing, it appeared to already be the case. The asylum application was probably past the 1 year deadline, it seems. The IJ then advised Mr. Trejo Tepas to obtain any paperwork so he could, quote, tell his side of the story, end quote, including letters from people in El Salvador. The IJ also advised that Mr. Trejo Tepas identify witnesses. The IJ, quote, strongly advised, end quote, that Mr. Trejo Tepas find an attorney. At the next hearing, which appears to have been a merits hearing, Mr. Trejo Tepas appeared without an attorney, but confirmed that actually someone from the wonderful nonprofit Catholic Charities had helped him complete an asylum application in 2018. A filing that, as it turns out, was already in the record. Doesn't seem like much else was submitted, though. Remember, he did not have an attorney representing him. Mr. Trejo Tepas feared the gangs in El Salvador. In that 2018 filing, and then at the merits hearing, Mr. Trejo Tepas repeatedly affirmed that neither he himself nor his family had had encounters with the gangs, though his classmates had been killed. Mr. Trejo Tepas stopped going to school in the 9th grade because of his fears of gangs. The IJ gave Mr. Trejo Tepas a final opportunity to tell the court anything else about his fear, and Mr. Trejo Tepas responded that he was scared of the gangs. The IJ denied relief and protection. Mr. Trejo Tepas then obtained an attorney and challenged everything based on the very recent decision at the time, Quintero, which outlined a bunch of due process protections due to pro se respondents in the Fourth Circuit, and particularly asylum seekers. Great quotes throughout that Quintero decision, if you recall. Give episode 57 a re-listen. The BIA, however, found that the IJ had satisfied Quintero, a decision that had not yet been released when the IJ ruled. The BIA dismissed the appeal, and the Fourth Circuit affirmed. In so doing, the Fourth Circuit did what often happens with very non-citizen-friendly precedent like Quintero. The panel reined that decision in a bit. At least in, quote, the particular circumstances of this case, end quote. First, some serious procedural arguments. Mr. Trejo Tepas argued that as a result of the ongoing class action JOP v. DHS, the whole matter should have actually been sent to USCIS and out of immigration court because Mr. Trejo Tepas was an unaccompanied minor applying for asylum. Oil retorted that Mr. Trejo Tepas failed to exhaust this argument and couldn't bring it for the first time on petition for review. A failure to exhaust an argument before the BIA is now a claims processing rule violation that can be waived by the circuit and the argument considered. It's not a non-waivable jurisdictional problem anymore, following the Supreme Court's decision in Santos-Zacaria this term. Problem is, explained the Fourth, is that Mr. Trejo Tepas actually did reference the argument in his notice of appeal before the BIA, but then he failed to brief it. The consequences of that under BIA rules is that you waive the argument. Under these circumstances, the Fourth Circuit wasn't going to excuse Mr. Trejo Tepas' failure to exhaust. And to be honest with you, in a footnote, the fourth doesn't seem to really believe in the argument on the merits, mainly due to Mr. Trejo Tepas' adult age when he actually filed the asylum application in 2018, and the fact that he was released into the care of his father shortly thereafter. Don't sleep on JOP v. DHS, though, if you've got the unaccompanied minor case. So the merits, then, are really the alleged due process violation a la Quintero. Under Quintero, for a pro se asylum seeker, an IJ has a, quote, duty to fully develop the record in a manner responsive to the particular circumstances of the case, including whether the applicant made a sufficient factual showing of his eligibility for relief, to give the IJ the additional duty to flesh out those facts and help the applicant articulate legally cognizable particular social groups based on those factual circumstances, end quote. What a standard to apply to IJs in the Fourth Circuit. Thing is that the Fourth Circuit agreed with the BIA that was done here. It is true that IJs in the Fourth must, quote, probe into, inquire, and elicit all facts relevant to the applicant's claim, end quote, and help craft a, quote, legally cognizable particular social group, end quote. But for the duty to attach, said the court, the asylum seeker must, quote, make a sufficient factual showing of their eligibility for relief, end quote. Apparently first. And an IJ can't, of course, transform into an advocate for either party, explained the panel. The Fourth Circuit here just didn't see enough facts to trigger the robust protections discussed in Quintero. To the court, the IJ probed and asked questions, but they all led to a, quote, dead end, end quote. At most, said the Fourth Circuit, Mr. Trejo Tepas, pro se, was presenting, quote, generalized fear of criminal gang members and violent conditions in El Salvador, end quote. But that doesn't get an applicant asylum. The IJ did all that was required under the circumstances presented. The Fourth Circuit also briefly addressed the merits of Mr. Trejo Tepas' claim itself. Likely doing the best with the record available, Petition for Review Counsel argued that Mr. Trejo Tepas was clearly due asylum or withholding of removal based on his membership in the particular social group of, quote, Salvadoran classmates of youth killed by violent and powerful gang members, and Salvadoran witnesses to school classmates killed by violent and powerful gang members, end quote. But Mr. Trejo Tepas was never harmed or approached, and the Fourth Circuit didn't believe here that that's why he had left El Salvador. Again, it believed that it was generalized gang terror affecting everyone in El Salvador. And the Fourth didn't see those particular social groups as legitimate. Mr. Trejo Tepas, therefore, lost his case. And we have now eaten our vegetables before we can get to the next one. And that is Trejo Tepas v. Garland. Still with the Fourth Circuit? You bet. This is Santos-Zacaria v. Garland, published by the Fourth on July 11th, 2023. And this case is about nexus. Mr. Santos-Zacaria is from El Salvador and fears the deadly 18th Street gang that operates in that country. He also fears the Salvadoran police. He's been granted asylum through 3 separate immigration judge decisions, but the BIA keeps reversing, every time, 3 times. Now Mr. Santos-Zacaria sits in El Salvador while it all gets duked out before the Fourth Circuit. What will happen now? Stay tuned and find out. Alright, here's what's up. MS-13 of the 18th Street Gang pretty much run the town that Mr. Santos-Zacaria is from. In 2012, his cousin Emily became involved with an 18th Street Gang member named El Baca. She tried to get out of the relationship when she learned about El Baca's gang ties, and at 15 years old, Mr. Santos-Zacaria prevented Emily from what appears to have been an attempted gang rape that included El Baca. Mr. Santos-Zacaria got beaten up by a group of gang members, but he was able to save Emily. The gang members gave Mr. Santos-Zacaria 1 week to leave the country, which he did, in December 2012, entering the U.S. as an unaccompanied minor with Emily. But a few years later, at 18 years old while living in Virginia, Mr. Santos-Zacaria was arrested for graffitiing offense with friends. Removal proceedings followed. Unclear why Mr. Santos-Zacaria never sought to legalize his status based on the fact that he was an unaccompanied minor, but then again, this stuff is very complicated, and it's largely the underfunded and overcapacity nonprofits working in that space. 18-year-old Mr. Santos-Zacaria, likely detained and without an attorney, accepted voluntary departure and returned to El Salvador. But it didn't take long for the gangs to find him again, where they essentially made the same threat: leave or die. The Salvadoran police were no help at all. Instead, multiple times they arrested Mr. Santos-Zacaria, seemingly thinking that he was a gang member himself based on his age, and they beat him pretty bad. Handcuffed to a chair and beaten while a plastic bag was held over his head by police. On another occasion, they beat him in the head with a police radio. Quote, Mr. Santos-Zacaria's troubles went on like this back and forth between the police and the gang for a few months. Not long after the second police incident, Mr. Santos-Zacaria was surrounded by 18th Street gang members in a public park and severely beaten with baseball bats and a bike chain. End quote. He fled back to Virginia in September 2016. Arrested again for a minor offense, driving without a license, and back in removal proceedings, in detention, where he was held for nearly 5 years. 5 years in immigration prison until his recent removal to El Salvador. And it looks like that just before a federal judge was going to mandate a bond hearing, the BIA ruled against Mr. Santos-Zacaria for the third time, and ICE quickly removed him to El Salvador. Wild stuff. Again, especially considering that IJs kept granting him asylum. It's a long decision, and there's no real need to get into all the back and forth between the IJ and the BIA. Seems like ICE was taking the position, though, that Mr. Santos-Zacaria was himself gang-affiliated, but the IJ wasn't buying that. Nor was the Fourth Circuit, which calls Ms. Santos-Zacaria's involvement in a gang, quote, unsubstantiated, end quote. Believe me, I'm saving you all from an absolute procedural nightmare of a case. Thank God for big firm pro bono counsel, sometimes. The Fourth Circuit reversed and remanded in part. In an excellent legalese insult, quote, the strength of Mr. Santos-Zacaria's appellate contentions is evidenced, to some extent, by the fact that he was affirmatively awarded immigration relief 3 times over by the IJ, with such relief repeatedly wiped out by the BIA on peripheral grounds, end quote. Lots going on in this one, so I'll focus on what the Fourth held to overturn the BIA, quote, here, discovering the BIA's error in rejecting Mr. Santos-Zacaria's proposed social group of young male family members of his cousin Emily is no Herculean task. Social groups based on family ties have been consistently approved by this court as providing a sound basis for asylum or withholding of removal applications, end quote. Indeed, long-standing precedent in the Fourth holds that family groups are the, quote, prototypical example, end quote, of a particular social group. Why? Well, as the Fourth Circuit and other courts and even the BIA have recognized, quote, being young and of a particular gender are common and immutable characteristics, end quote. So too, quote, kinship ties and family bonds are paradigmatically immutable and innate and unchangeable, end quote. All of that seems pretty applicable to a lot of particular social groups. Then, casting Bill Barr's wishes to the wind, the Fourth Circuit reaffirms that there are, quote, few groups more readily identifiable in society than the family, end quote. So that's immutability and social distinction of the family-based particular social group. On the last element for PSG's, particularity, which already has a really favorable legal standard in the Fourth Circuit, the court quickly explained that the Fourth has, quote, repeatedly recognized family groups far more general than young male family members of Emily, as sufficiently particular, end quote. Family-based particular social groups need not be limited to the nuclear family, explained the Fourth Circuit expressly in a quote that everyone should use. Withholding of removal therefore remanded. To be honest, I kind of got lost on why asylum wasn't at play too. I feel like it might still be. Anyway, hope Mr. Santos-Zacaria is okay, because he's coming back. Pretty incredible to physically remove an asylum seeker pending petition for review, no? The Fourth Circuit agreed, however, that the record did not show that Mr. Santos-Zacaria was persecuted on account of an imputed political opinion. Rather, it was reasonable to believe that the gang was targeting him for what he had helped to prevent with Emily. It still might satisfy a family-based nexus, but it's not an imputed anti-gang political opinion here. The Fourth Circuit also, though, does have beef with the BIA's Convention Against Torture denial. The IJ looked at a whole lot of evidence to find that Mr. Santos-Zacaria, quote, would more likely than not be tortured by a combination of the 18th Street Gang, the Salvadoran police, and the vigilante anti-gang death squads if he were removed to El Salvador. But the BIA then overturned the IJ by relying on simply two pieces of evidence. The Fourth Circuit thinks that the BIA excluded lots of evidence, and, quote, when a man's life is on the line, he is entitled to know that the court deciding his claim reviewed all his evidence, understood it, and had a cogent, articulable basis for its determination that his evidence was insufficient, end quote. Plus, the Fourth Circuit totally sees the cat claim here. What a mess. Major congratulations to Jessica Leigh Wagner, David DeBold, and Naima L. Farrell from Gibson Dunn. Nice pro bono win, guys. Looks like Judge Quattlebaum dissented in all ways relevant. Here's more. In a perhaps unintentionally consequential footnote, the Fourth Circuit essentially says that the BIA must follow the Fourth Circuit's, particular social group precedent over that of the BIA or the Attorney General when deciding cases in the Fourth. No small footnote holding, given the ambiguity of the phrase particular social group, and actually the potential need for Chevron or Brand X deference. But there it is, and Chevron and Brand X are probably dead cases walking anyway. Also, in a footnote of course, for all of you litigating in the cat space who hate matter of J-F-F, the Fourth Circuit held in the 2019 pre-podcast decision Rodriguez-Arias v. Whitaker that Convention Against Torture applicants are not, in fact, quote, required to establish a specific chain of events leading to torture, end quote. That's so important that it's going in the case note of this decision, even though that's not what this decision is about. And that is Santos-Zacaria v. Garland. Our last Fourth Circuit decision is Lazo-Gavidia v. Garland, published by the Fourth Circuit on July 12, 2023. Like I mentioned, the Fourth Circuit is having a couple of weeks here, but I am here for it. Let it out, Fourth Circuit! And this is a big one. Apparently seeing how much fun its sister circuit, the Third Circuit, was having at the deficient NTA and absentia motion to reopen party last week, the Fourth Circuit wanted in. Welcome, Fourth Circuit! Judge Rushing dissented. And I mean, we just did this issue last week. I'll therefore try to be quick and highlight notable portions. Famous last words. Miss Lazo-Gavidia and her minor son are asylum seekers from El Salvador. They were apprehended in Texas and placed in removal proceedings, but the notices to appear that kicked off removal proceedings didn't have the date and time of the first hearing. Miss Lazo-Gavidia was warned in Spanish of the consequences of not appearing for her hearing, and that she needed to notify immigration officials if she changed her address. Upon her release from immigration custody, Miss Lazo-Gavidia provided a Burlington, North Carolina address to immigration officials. She even then reported to her first ICE check-in with ICE in Charlotte. She received a new appointment date for a year later for her ICE check-in, as so often occurs. Then she moved addresses in Burlington, but she didn't tell any immigration officers. She therefore didn't receive the notice of hearing from the immigration court, scheduling her first removal hearing for January 2020 in the Charlotte Immigration Court. Ordered removed in absentia when she didn't appear, she learned about it all a month later. She immediately moved to reopen and rescind the in absentia removal order. The IJ and then the BIA denied, finding that Ms. Lazo-Gavidia had not rebutted the presumption of delivery and receipt of the hearing notice at the address she provided, end quote. A finding that likely would have stood in our pre-Pereira and Ms. Chavez world through like a summary order amounting to 2 pages. But we are not in that world, and the Fourth Circuit reversed. Similar, if not identical, rationale to that used by the Third Circuit last week. Because after all, it's the same statute. A quote, non-citizen can move for rescission of a removal order at any time if she did not receive notice in accordance with, end quote, INA Section 239A. And a deficient NTA is not in accordance with Section 239A, which of course defines what must be in an NTA. Now it's true that another statute holds that, quote, if the non-citizen fails to provide or update her address, no written notice shall be required for removal, end quote. That's essentially the statute relied upon by the 11th Circuit to reach an opposite conclusion in Castagomez-Aguilar, episode 117. But the 4th Circuit instead agreed, by my count, with the 1st, 3rd, and 9th Circuits, to hold that the address update requirements be damned. Also, I believe that this argument might have some legs in the 5th Circuit so long as that initial address provided by the non-citizen was correct. So I believe Ms. Lazo-Gavidia might win in the 5th Circuit, but I'd have to check my notes on the 7 decisions or so that the 5th Circuit has issued on this issue. Don't quote me on it. Instead, quote Ms. Chavez, like the 4th Circuit did, recognizing that, quote, Congress took pains to describe exactly what the government had to include in a notice to appear, and that the time and place of the hearing were among them, end quote. Can't save a deficient notice to appear with a notice of hearing, at least in the in absentia removal context. Went downhill for the government from there, quote, not only is Ms. Lazo-Gavidia permitted to seek rescission, she is also entitled to rescission. That's because the immigration court did not have the authority to order her removed in absentia in the first place, end quote. The 4th Circuit rejected Oyle's argument that Ms. Lazo-Gavidia's failure to update her address tanked her case. And the dissent agreed with Oyle. But to the majority, it was the same problem identified by the 3rd Circuit last week. The punishment of not updating your address only applies to changes or postponements of your immigration court hearing. But you can't change or postpone something that wasn't ever set in the first place because the NTA was deficient. It all comes back to whether that notice to appear complied with INA Section 239A. Ms. Lazo-Gavidia wins, gets to reopen her case, and gets to seek asylum. Before ruling for Ms. Lazo-Gavidia, the 4th Circuit dedicated quite a few pages to explaining why the 11th Circuit is wrong, dead wrong, in Castagomez-Aguilar. The focus is on the NTA, not the notice of hearing. Quote, indeed, taken to its logical conclusion, the 11th Circuit's position would effectively eviscerate the protections provided by a valid notice to appear, end quote. I agree, 4th Circuit. Heads up, too. Seems like even the 11th Circuit is a bit all over the place, as it granted a similar case post to Castagomez-Aguilar. Unpublished, but peep page 12 of this decision here for the citation, 11th Circuit practitioners. Or check out my Twitter feed where Mark Prada provided it. I believe it's his case. As to Ms. Lazo-Gavidia's failure to update her address, again, doesn't matter. The original sin is the deficient NTA, and anything that happens afterwards with the notice of hearing is irrelevant, it would appear, in, of course, the in absentia reopening context. As Judge Rushing explains in dissent, quote, after the majority's decision, every non-citizen who was removed in absentia after receiving an incomplete NTA can obtain rescission of her removal order, regardless of whether she was provided an address at which she could be reached and regardless of whether she actually received the notice but chose to skip her removal hearing, end quote. Congratulations, Herbert Glenn Fogel Jr., for petitioners. A growing circuit split on an issue that affects like tens of thousands of non-citizens since 1997, albeit on the side of non-citizens. There's still time to be on the right side of this, BIA. If the Supreme Court doesn't take up this issue within the next 2 terms, I swear here and now that I will eat the strangest food that any listener emails to me, provided that that food can be found on a menu in San Diego. But I am confident that I will win this bet. And that is Lazo-Gavidia v. Garland. This podcast is sponsored by Journey Business Plans. Journey is the leading business immigration plan writing company in the United States. 10 years. And they know immigration. Heck, they started as an E2 company themselves. Journey prides itself on its responsiveness and overall customer service, preparing business plans for E2, EB2 NIW, L1, EB5, and much more. If you don't yet know about Journey, and don't want to listen to just me, ask your colleagues. Or even better, try them out. Visit www.journey.com and use promo code REVJOURNEY30 for a 30% discount on your first business plan. That's REVJOORNEY30. or click on the link in the show notes. This podcast is also sponsored by Capital Good Fund. Millions of families seeking to improve their immigration status face financial barriers due to the high cost of legal services. Nonprofit Capital Good Fund is working to make these resources available to all, especially those who would otherwise not qualify for traditional loans. Certified CDFI Capital Good Fund is partnering with attorneys to provide the financial services families need. They offer affordable financing with no closing fee or down payments for those working with attorneys to move their case forward and get attorneys out of the accounts receivable business. To learn more about the program, email immigration@goodfund.us or call 866-584-3651 and tell them who sent you. Done with the Fourth Circuit, but not even halfway done with the week. Next is Sanchez v. Garland, published by the First Circuit on July 14th, 2023. This case is about particular social groups. Mr. Sanchez is from El Salvador. He entered the United States without authorization in March 2014. His wife and child remained behind in El Salvador, but joined Mr. Sanchez in 2016. His wife has another adult child in El Salvador, while the couple share a child born in the United States. Mr. Sanchez owned a fruit stand in El Salvador. On 2 occasions, a member of the Barrio 18 gang approached him and handed him a cell phone. Both times, the person on the other end of the line demanded extortion of $100 a week, at threat of murder. Mr. Sanchez never reported it because he knew of people getting killed after reporting such things to police. Several of his extended family members had had similar experiences too, some of them kidnapped, tortured, and killed. All of this is what motivated Mr. Sanchez's flight. About a year later, his wife's brother was killed for similar reasons. Then a year after that, the extortions began against Mr. Sanchez's wife. Quote, she stated that the man pressed a weapon into her right side and demanded that she pay him $3,000, end quote, while she was on her way to the grocery store. The man knew that her husband was in the United States and had money, he explained. The man said he'd kill her like he killed her brother if she didn't pay. Mr. Sanchez and his wife, though, weren't sure if this guy was in a gang. Mr. Sanchez's wife fled to the United States 5 days later. Both Mr. Sanchez and his wife testified at their joint asylum hearing in immigration court. Deemed credible, the IJ nevertheless believed that what they had suffered wasn't so bad, and in any event it wasn't on account of any protected ground. Quote, Salvadoran business owners perceived as wealthy, end quote, is not a particular social group, explained the immigration judge. Nor did the IJ believe that the experience occurred on account of their family membership, the BIA affirmed. As did the First Circuit. It didn't believe that business owners perceived as wealthy was something that Salvadorans cannot or should not be required to change, not immutable. Nor did the First Circuit see that group as socially distinct, separate, in Salvadoran society. As to the other determination that Mr. Sanchez and his wife didn't experience all of this on account of their family membership should be, quote, at the root of the persecution, so that family membership itself brought about the persecutorial conduct, end quote. That's what this panel believes the standard is in the First Circuit, a standard that kind of appears a bit at odds with all those things we were just discussing from the Fourth Circuit. But, to the First Circuit, quote, such claims fail where multiple family members happen to be persecuted for a common reason, but the reason for animus is not kinship, end quote. That's what the First Circuit saw here. This was mainly about simple extortion. Withholding and Convention Against Torture Protection denied too, and so the First Circuit denied the petition for review. And that is Sanchez v. Garland. Moving on. Argueta Hernandez v. Garland, published by the Fifth Circuit on July 10th, 2023. This case is about untimely petitions for review, so it's not going to end well for the non-citizen. Ms. Argueta Hernandez is from El Salvador and has been removed from the United States and unlawfully re-entered several times. In September 2019, DHS reinstated a 2007 removal order. Seems like Mr. Argueta-Hernandez actually made it into removal proceedings to litigate a gang-based withholding of removal claim, but he lost, and the BIA affirmed that denial on April 27, 2022. Mr. Argueta-Hernandez petitioned for review on May 26, 2022. Seems timely to me. Au contraire, said the Fifth Circuit. The INA only grants circuits jurisdiction to review final orders of removal. And a petition for review of Mr. Argueta-Hernandez's final order of removal was due sometime in 2007 when he actually received that removal order. That removal order, if you recall, was reinstated, and then Mr. Argueta-Hernandez ended up in withholding-only proceedings. But when an IJ and the BIA deny withholding in withholding of removal proceedings, there's already a final order of removal. The non-citizen is simply asking the IJ and the BIA to withhold it. Now, of course, many circuits have held that they, the circuits, have authority to review denials of withholding or Convention Against Torture Protection in these exact circumstances. When a non-citizen after reinstatement is placed in withholding-only proceedings and then loses, and then petitions for review the denial of withholding or CAT to the circuit. But the Fifth Circuit sees it differently, instead opting to align with the very confusing Second Circuit holding in Bakhtabai Patel v. Garland, episode 105. Seems like the Fifth Circuit actually saw it the same as those other circuits in 2016, but it believes that the Supreme Court's Nasrallah decision, which had nothing to do at all with this issue, quote, implicitly overruled, end quote, its 2016 precedent and mandates this new jurisdiction-stripping rule. A rule that, in effect, will make it impossible, as I see it, for any non-citizen subject to reinstatement to ever have his or her withholding of removal or Convention Against Torture denial reviewed by the Fifth Circuit following a denial in withholding-only proceedings. To the court, a, quote, removal order concerns whether a non-citizen is to be removed, not where, end quote. The Fifth Circuit believes that withholding of removal and Convention Against Torture concern the latter, not the former. That is jurisdictionally significant and bars review for Mr. Argueta-Hernandez. To be very clear, I now see no way to challenge a denial or withholding of removal or CAT protection in the Fifth Circuit where DHS has reinstated a final order of removal. Seems like something that Congress would have expressly said in the INA if that's what Congress wanted. Tell me if you disagree. But with such sweeping logic comes a ray of light for non-citizens. In reaching this holding, the Fifth Circuit cites to Nasrallah v. Barr to hold that, quote, the Supreme Court recently held that orders denying CAT relief or withholding of removal are not orders of removal, end quote. As such, explained the Fifth Circuit, the INA provisions that attach to final orders of removal are separate when CAT and withholding of removal are what are at issue. But really, in Nasrallah, the Supreme Court was just adjudicating CAT protection, not withholding. But, as I and many others have been saying from the get-go of Nasrallah, and as the Fifth Circuit clearly is agreeing with here, all the logic of Nasrallah and its holding that circuits have authority to review IJ and BIA findings of fact underlying a denial of CAT protection apply equally to challenges of the denial of withholding of removal, even when the non-citizen has committed a very serious crime. I agree, Fifth Circuit. Thanks for making it clear. And that is Argueta-Hernandez v. Garland. Next up are two from the 8th. First, Arroyo Sosa v. Garland, published by the 8th Circuit on July 13th, 2023. This case is about, I guess, motions to reopen? Mr. Arroyo Sosa is from Mexico and entered the United States without authorization in 2000. Placed in removal proceedings in 2017 or so, he filed an application for asylum and related relief, claiming, quote, as a former member of a Mexican paramilitary group, he would be subject to violence from organized crime members if he were to return to Mexico, end quote. Things got weird at the individual hearing, though. It seems that Mr. Arroyo Sosa had submitted an affidavit to the court complaining about his current attorney, and filed by another attorney, likely in support of a motion for that other attorney to substitute as counsel. But then the first attorney, the one that Mr. Arroyo Sosa complained about in an affidavit, was actually the one representing him at this individual hearing. Mr. Arroyo Sosa told the IJ that everything was cool now, and that he did not know that that second attorney had apparently filed a bar complaint against his current attorney on Mr. Arroyo Sosa's behalf. What a mess. That bar complaint had been withdrawn, though. Seems like a lot of this was about money. All appears to have happened over like a 24-hour period shortly before the individual hearing. Ultimately, Mr. Arroyo Sosa confirmed that he wanted this attorney to represent him, that first attorney. Testifying in support of his claim, Mr. Arroyo Sosa expressed fear that he would be harmed, quote, by the drug cartels due to his membership in the particular social group defined as Elite Paratrooper Brigade of the Mexican Air Force, and his political opinion of fighting in a unit that combats the drug cartels, end quote. The IJ found Mr. Arroyo Sosa unresponsive and not credible. The IJ refused to hear 2 additional witnesses because the IJ believed that those witnesses couldn't help Mr. Arroyo Sosa, where he himself was not credible. Also, the IJ believed Mr. Arroyo Sosa's asylum application was untimely. The IJ alternatively denied everything on the merits. That first attorney who represented Mr. Arroyo Sosa here, post-bar complaint, filed an appeal with the BIA, and then passed away. New counsel then came in and alleged ineffective assistance of counsel. The BIA affirmed the denial of relief and refused to remand for ineffective assistance. Mr. Arroyo Sosa moved to reopen and or to reconsider, which the BIA denied. The Eighth Circuit affirmed the BIA. The court first dispensed with the motion to reconsider denial. To the court, the BIA considered the evidence and arguments that Mr. Arroyo Sosa submitted with his motion, and the BIA didn't believe that it satisfied the required reconsideration standard. The BIA had already considered the evidence and arguments Mr. Arroyo Sosa had submitted, and didn't believe it satisfied the required legal standard. So actually, to the Eighth Circuit, there wasn't much need for the BIA to reconsider anything. On a motion to reopen that appears to be either concurrent or filed shortly thereafter, the Eighth Circuit affirmed the denial of that motion, too. Rather than pointing out that the BIA made an error previously, as reconsideration would require, a motion to reopen would require new and previously unavailable material evidence. This argument had a little more legs. See, Mr. Arroyo Sosa had also applied for and been denied non-LPR cancellation of removal under INA Section 248B below. He sought to reopen to present new hardship evidence, and argued that the BIA had applied the wrong legal standard to the hardship determination the first time around, it seems. For such motions, the BIA's decision in matter of Coelho gives a non-citizen, quote, the heavy burden of showing that the new evidence presented would likely change the result in the case, end quote. But shortly after that, in matter of Log, the BIA required a showing only of, quote, a reasonable likelihood of success on the merits, end quote. Seems like a lower standard than Coelho for motions to reopen, right? But all this has been around for a long time, and the Eighth Circuit has reconciled Coelho and Log. To the Eighth Circuit, Coelho applies where the non-citizen, quote, had an opportunity to fully present and litigate his request for discretionary relief from deportation before the immigration court, end quote. So it seems then that in the Eighth Circuit, Log only applies when the claim sought to be adjudicated in the motion to reopen is completely new? Need to go back and check. In any event, though, to the Eighth Circuit, the BIA actually applied the lower matter of Log standard here, so all good. On the merits, the Eighth Circuit also found that it lacked jurisdiction to consider whether the BIA applied the wrong hardship standard. Sigh. Nor, continued the Eighth Circuit, did the IJ, quote, violate his due process rights when he repeatedly interrupted Mr. Arroyo Sosa, cut off his testimony, and would not allow him to present additional witnesses to testify in support of his applications, end quote. Nor was the IJ or BIA so wrong to deny asylum, because at a minimum, the 1-year filing deadline finding was never challenged and is dispositive. Looks like withholding and CAT weren't challenged on petition for review. Weird case all around. Not for nothing. Unlike what the Ninth Circuit kinda just held a few weeks ago, The Eighth Circuit did hold that it had jurisdiction to consider a denial of a motion to reopen to apply for non-LPR cancellation of removal, even if Patel would divest the Eighth Circuit of jurisdiction to review the denial of non-LPR cancellation itself. So there's that. And that is Arroyo Sosa v. Garland. Next up is Thak v. Garland, published by the Eighth Circuit on July 13th, 2023. This case is about aggravated felony theft offenses. Couldn't do a week without crimmigration. Mr. Thak is from Sudan. Unsure how he entered the United States or got his green card, but he did. But a few years later, he was convicted mostly, if not entirely, of nonviolent crimes that an immigration judge determined made Mr. Thak removable and barred him from all relief in removal proceedings except deferral of removal under the Convention Against Torture. And then the IJ granted it, at least as to South Sudan. The IJ ordered and did not defer Mr. Thak's removal to Sudan. And if I'm doing my math right, South Sudan wasn't even a country yet when Mr. Thak entered the United States. So I have a feeling that Mr. Thak is actually from the region of what is now South Sudan, and that actually, maybe under Sudanese law, he can't actually be removed to Sudan, even though he was born there. And so the grant of deferral to South Sudan, in effect, permits Mr. Thak to remain in the United States indefinitely. Just a thought. Both Mr. Thak and DHS appealed. The BIA denied Mr. Thak's appeal, but granted DHS's, vacating the IJ's grant of cat deferral, meaning that Mr. Thak had a final order of removal that would be enforced as to both Sudan and South Sudan, whichever would take him. Following some procedural maneuvers that I'm not going to get into, it all got to the Eighth Circuit, which reversed the BIA. But not on cat deferral, actually. Turns out Mr. Thak isn't removable in the first place. See, despite quite a few crimes, due to the categorical approach and the Supreme Court's decision in Bourdain, the only actual crime eventually at issue before the Eighth Circuit was a 2018 shoplifting felony conviction that the IJ and the BIA believed to be an aggravated felony theft offense at INA Section 11843G. The statute is Nebraska Revised Statute Section 28-511.01. But it's not a theft aggravated felony. Section 11843G only includes state crimes that necessarily require the, quote, taking of or exercise of control over property without consent whenever there is criminal intent to deprive the owner of the rights and benefits of ownership, even if such deprivation is less than total or permanent, end quote. Okay, fine. But again, generic theft requires a mens rea of, quote, criminal intent to deprive the owner of the rights and benefits of ownership, end quote. The Nebraska statute requires that mens rea, but it also allows conviction where the defendant had the mens rea of, quote, appropriating goods or merchandise to his or her own use without paying for the goods or merchandise, end quote. In Nebraska, an intent to appropriate captures an offender like shoplifting for his or her own use, whereas the intent to deprive captures an offender shoplifting to deprive the owner. As both the 5th and 11th Circuits have found, no bastions of non-citizen-friendly precedent, those two, an intent to appropriate for one's own benefit does not necessarily also mean that the actor intended to deprive the owner. How can one appropriate goods for their own use but not also intend to deprive the owner of the use of those goods? Beats me. But it's got to mean something different, because the Nebraska statute and many statutes can be committed with either intent. By the way, that 11th Circuit decision is Ramos v. U.S. Attorney General, a KKTP win, thank you very much. I wasn't around yet. Anyway, the 8th Circuit explains it. Quote, for example, an individual, when taking an item for his own benefit, may know that the owner will be deprived of possession of that item, even though he does not consciously desire that result, end quote. That's appropriation, not an intent to deprive. And when mens rea is at play, what the actor is thinking and intending means everything. Mr. Thak is not removable. Forget about lowly cat deferral, he gets to keep his green card. Congrats, counsel! I wish the 8th Circuit put the attorneys in their day of decision publications. Never give up. And that is Thak v. Garland. we come to the end. Whitaker v. Garland, published by the Second Circuit on July 12, 2023. We conclude with a very long decision about ineffective assistance of counsel. And U visas, and other things. Mr. Whitaker is from Ecuador and has lived in the United States since he entered without authorization in 1999 at 17 years old. He's married and has U.S. citizen children. He filed an affirmative asylum application in 2012, seemingly, it appears, simply to be placed in removal proceedings, where he then withdrew his asylum application and applied for non-LPR cancellation of removal under INA Section 248B. Unethical, probably illegal, and risky AF. Not that it matters ethically, but it's also not like the U.S. citizen children had glaring issues that screamed exceptional, extremely unusual hardship, at least the evidence presented to the immigration judge. Nor did counsel really make the showing. Counsel asked 4 questions about hardship on direct before the IJ. An immigration judge denied in 2018 and ordered Mr. Whitaker removed. On appeal to the BIA through new counsel simultaneously moved to remand based on ineffective assistance of counsel. That motion included a sworn declaration from Mr. Whitaker attesting that his old lawyers promised him he could get a green card because he'd been in the U.S. for 10 years. There are a few more requirements than that for non-LPR cancellation. The asylum application was untimely when he filed it with USCIS, so it was totally going to be denied, and of course it was withdrawn once placed in removal proceedings. Seems like prior counsel totally did this unethical thing. Nor did prior counsel ever tell Mr. Whitaker the requirements for non-LPR cancellation. So attested Mr. Whitaker. Also, eventually, 33 plaintiffs filed a civil fraud case against this old law firm, the Hecht law firm, including Mr. Whitaker, and it settled in April 2020. Plus there were bar complaints. It would appear that they did it. Not only that, but there was apparently more hardship to show if we're talking non-LPR cancellation. The Hecht law firm did show that one of Mr. Whitaker's children had asthma, but apparently that asthma is much worse than what was established before the immigration judge, and it appears that the child has psychological difficulties as well. Finally, to put a bow on it, Mr. Whitaker was cooperating with law enforcement in an investigation against his prior attorneys for fraud. That, therefore, may support a U visa in the future. So argued new counsel. Perhaps warranted here, but my God, the perverse incentives immigration creates for attorneys to come after other attorneys is an unfortunate reality. The BIA denied it all. Then it reopened the case on its own. Then the U visa was submitted, and Mr. Whitaker provided evidence to the BIA, along with even more serious hardship evidence for one of his children, which included the child's suicidal ideation and related 2-week hospitalization and depression diagnosis. But a divided BIA then denied everything again. The BIA majority agreed that counsel had been ineffective. It just didn't think that effective counsel, even with all of this new evidence, would have changed the IJ's mind on Mr. Whitaker's eligibility for non-LPR cancellation of removal. They were probably still peeved that an asylum application was filed with USCIS just to get Mr. Whitaker into removal proceedings. The Second Circuit disagreed with the BIA majority's holding. Unlike at least the 11th Circuit, if I'm not mistaken, the Second Circuit did not hold that Patel divested it of jurisdiction to consider the BIA's denial of the motion to remand for ineffective assistance of counsel, even though the ultimate relief requested was a hardship issued tethered to non-LPR cancellation, which would almost certainly not be reviewable if challenged on direct petition for review. So thank you, Second Circuit. As even the BIA recognized, the sole issue there then was whether the Hecht law firm's ineffective assistance prejudiced Mr. Whitaker. If it did, he gets his remand. Quote, to establish prejudice in this context, Mr. Whitaker must show that but for counsel's unprofessional errors, there is a reasonable probability that the IJ would have granted the relief Mr. Whitaker requested. End quote. This in turn requires that the applicant make a prima facie showing that but for the ineffective assistance, he'd have been eligible for the relief and, quote, could have made a strong showing in support of his application, end quote. This in turn means merely a reasonable probability of a grant. It does not require that the grant be, quote, likely, end quote. To the Second Circuit, the BIA applied too heavy of a legal burden here. It kept citing to matter of Coelho, and that decision's language that non-citizens have a heavy burden when establishing grounds for reopening a case. But this is not a motion to reopen. This is a motion to remand for ineffective assistance of counsel. And more to the point, the heavy motion to reopen burden is distinct from the prejudice burden required to succeed on an ineffective assistance of counsel motion. Remember that. Quote, "At no point did the BIA cite the correct reasonable probability standard for evaluating prejudice," end quote. And the analysis that the BIA did do was clearly overly harsh. To establish prejudice, Mr. Bakar, quote, "need not conclusively establish his entitlement to relief," end quote. What a week for quotes, truly. Nor did it matter that some of the asthma stuff was actually considered by the IJ. There was much more evidence, not to mention the new mental health stuff, to establish the hardship Mr. Bakar's child would suffer without him. Additional evidence unconsidered by the IJ because of ineffective assistance of counsel. Also explained the Second Circuit, the BIA, quote, "overlooked and mischaracterized the record evidence of the child's serious mental illness," end quote, particularly the evidence of the depression diagnosis and treatment. Can't do that. Vindication to the BIA dissenter. Case remanded. The Second Circuit also addressed whether a remand was required to wait receipt of a U visa. Remember, Mr. Bakar was cooperating with law enforcement against his prior ineffective attorneys? In the 2012 decision matter of Sanchez-Sosa, the BIA outlined a framework for when IJs should and should not grant continuances to allow USCIS to consider a pending U visa. The BIA here didn't apply matter of Sanchez-Sosa to Mr. Bakar's motion to remand, it seems, because Mr. Bakar hadn't even asked for a continuance to await a U visa below, because there wasn't even a U visa filed before the IJ yet. Instead, what was happening is that Mr. Bakar was asking for a remand based on a U visa that was filed while the appeal with the BIA was pending. Not the same thing as asking for a continuance, which is what matter of Sanchez-Sosa was all about, it appears. But it's an open question whether matter of Sanchez-Sosa applies in these circumstances. The Eighth Circuit held that it was error to not apply Sanchez-Sosa in such circumstances in 2019. So did the Seventh Circuit in 2020, and so did the First in Benitez v. Wilkinson, episode 40. The Second Circuit agreed. No gong. Quote, "It does not matter whether Mr. Bakar initially requested a continuance from the IJ or whether his motion to remand was filed while proceedings were ongoing," end quote. The BIA should apply the multi-factor analysis for matter of Sanchez-Sosa to determine whether remand is warranted where a U visa is filed with USCIS for the first time while the case is on appeal with the BIA. So yeah, that's kind of an important rule. Therefore, congratulations Lindsay Nash and Catherine O. Greenberg from the Immigration Justice Clinic in New York, and to Paige Austin from Make the Road New York for petitioner. And that is Bakar v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend, and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate for 5 credit hours, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all. And follow the show on Instagram and Facebook at Immigration Review, and send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.